14. Stuart MacDonald to move Amendment 14.
Thank you again, Mr Stringer. I've been kept busy this afternoon. Again, I'm very pleased to move Amendment 14, and once again it's all about family, and what we're talking about here is what became known as the Surinder Singh route because of a judgment of the European Court of Justice. So I'll go back to what I said in my previous contribution in relation to all the unfairness of separation that immigration rules can cause, and this is coupled in the case of Surinder Singh families by a real sense of unfairness and a loss of a legitimate expectation. So what we're talking about here are UK citizens that have gone to live somewhere across the EEA at a time when the rules were quite clear that UK was part of the European Union, and so there would never be any conceivable difficulty about being able to return to this country with family that they may have settled down with in another EU country. And so to my mind, we should say they had a legitimate expectation when they left that they would be able to return at the appropriate moment with their EU family members to this country. But the problem of course arises now that if they return after the transition period the government has put in place, and it's better than nothing, that's absolutely true, they will instead be faced by the £18,600 threshold that I previously alluded to. So there are folk over there who have really huge dilemmas to address, and the briefing that we've had from British in Europe sort of sets out what's a very, very typical example, and it sets out the case of Sarah, a 48-year-old British national living in Germany with a 52-year-old German husband and children. She's the only child of an elderly mother in the UK. Career and schooling reasons mean that she cannot realistically return to the UK by March 2022. But what happens if her mother becomes so frail or ill that she needs to care for the care of her daughter in 5 years' time? She will have a huge decision to make. She'll either have to uproot her family at a time which is hugely disruptive and inconvenient in order to come back to look after her mother, or she'll have to leave her family behind and come back to look after her mother, or she will just have to hope that her mother is able to cope. It's not that she was negligent in going abroad and not taking this future prospect into account when she made the decision to travel and live in Germany, because it just didn't arise. We were part of the EU, and free movement was always going to enable that to happen. So while I'm grateful and welcome the fact that the government hasn't made this an immediate cut-off, 2022 is not enough. Why don't we just have an open-ended cut-off for people from this country who have made their lives in other parts of the European Union and the EEA, let them return here under the regime that was in place when they left, and that is the purpose of Amendment 14, and I hope it will have a sympathetic hearing. Thank you, Mr. Strong.
Amendment 14 is proposed to clause for as on the amendment paper. The question is that the amendment is made.
Thank you, Mr. Stringer. And once again, we are very sympathetic to Amendment 14. As we've already heard, it's not dissimilar to Amendment 1, and it would offer reassurance to the 1.2 million British nationals who live in EU countries. Failure to implement such measures that are proposed in the amendment would show the government's indifference to British citizens who decided to make their homes and lives in Europe, and in the example that we've just heard, potentially force people to choose between loved ones who are there and loved ones who are here. The example provided by British in Europe paints a picture which is affecting thousands of people and has the potential to affect thousands of people in the future as family members age and their circumstances change. This amendment characterises the significance of forming laws and policies in that what is discussed and decided upon in this building has far-reaching implications and consequences that affect vast swathes of people in their day-to-day lives. Until March 2022, any citizen who went to live in an EU 27 country did so with the security of knowing that if they were to form a relationship and or have a family, then they would have the right to return to the UK with that partner and family, whether either none or very little conditions attached. And this is the point that I made to the Minister in challenging and seeking further clarification on some of the points that he made about differences being potentially discriminatory for UK citizens returning and spouses who were from other parts of the world and not just EEA countries. As I'm sure we can all appreciate, families and relatives can be complex, and the provisions afforded to British citizens through freedom of movement would allow any citizen to return to the UK with their partner and family if a situation arose where they needed to do so, and potentially at quite short notice. If the UK citizen returned to be either employed or self-employed, there were no conditions to their return. If they returned to be a student or to be non-economically active, they would have to have sufficient resources not to become a burden on the social assistance system of the UK and have comprehensive health insurance. Comparatively, new immigration rules propose that spouses and partners who wish to enter the UK with their British partner will have to meet the minimum income requirement of £18,600. This figure is increased if the family have children, and it's a wholly restrictive requirement that will severely deter families from returning and coming to the UK. In some cases, may stop British citizens returning to the UK altogether. As highlighted in evidence by Jeremy Morgan, the right of citizens to return with their families to the country of origin was deemed outside the scope of the UK-EU withdrawal negotiations, resulting in a serious inequality between UK citizens in the EU and EU citizens in the UK. Bizarrely, the UK government is discriminating against its own citizens in this instance. EU nationals continue to enjoy the right to return to their countries of origin with their non-EU family members. Furthermore, EU citizens resident in the UK and covered by the withdrawal agreement also have an unconditional lifelong right to bring all family members, including non-EU, to the UK, provided the relationship existed before the end of the transition period. The amendment put forward would address this discrepancy. The coronavirus pandemic has only heightened the need for the government to carry out its basic duty and support UK citizens living abroad. What if this pandemic had occurred after the 29th of March 2022? As countries begin lockdown, British citizens in Europe would have been faced with the unenviable choice of remaining or hastily returning to the UK. The minimum income requirement would have meant that many British citizens and their families would have been simply unable to return, despite both global and personal crises.
Yes.
Well, thank you, Mr. Stringer, and I again thank the honourable member for Cumbernauld, Kilsyth and Kirkintilloch East and his colleagues for tabling Amendment 14 and allowing us to have this discussion. As the honourable member has said, this amendment would require the government to include in regulations made in consequence of this bill ending EU free movement law lifetime rights for UK nationals to bring their close family members to the UK on EU free movement terms, whether the UK national was resident in the EEA or Switzerland in accordance with EU law by the end of the transition period at the end of this year. These family members would thereby continue indefinitely to bypass the immigration rules which otherwise apply to family members of UK nationals. I will set out the government's policy for this cohort of family members before I explain the reasons for rejecting this amendment. In certain circumstances, family members of UK nationals who have resided together in the EEA or Switzerland are able to come to the UK under EU free movement law. This applies where a UK national has exercised free movement rights in the host state, for example as a worker or self-employed person for more than 3 months. This is sometimes referred to as the Surinder Singh route after the relevant judgment of the Court of Justice of the European Union. Surinder Singh family members are not protected by the withdrawal agreements, as was touched on by the shadow member. Nonetheless, as a matter of domestic policy, the government decided UK nationals resident in the EEA or Switzerland under EU free movement law by the end of the transition period, the end of this year, will have until the 29th of March 2022 to bring their existing close family members, a spouse, civil partner, durable partner, child or dependent partner, to the UK on EU law terms. The family relationship must have existed before the UK left the EU on the 31st of January 2020, unless the child was born or adopted after this date, and must continue to exist when the family member seeks to come to the UK for fairly obvious reasons. Other family members, such as a spouse, where the relationship was formed after the UK left the EU, or other dependent relative, have until the end of the transition period on 31st of December 2020 to return to the UK with a qualifying UK national on EU free movement terms. If they return to the UK with a qualifying UK national by the relevant date, all these family members will then be entitled to apply for status to remain here under the EU settlement scheme. If they do not return to the UK with a qualifying UK national by the relevant date, they will need to meet the requirements of the family immigration rules then applicable at the time if they wish to come to the UK. The government believes this fair and balanced policy is appropriate, and it was developed after listening to the concerns of UK nationals living in the EEA or Switzerland, many of whom decided to relocate there before the outcome of the EU referendum in June 2016, on the understanding they would be able to return to the UK with their family members on EU law terms. The policy was announced on the 4th of April 2019 to give UK nationals almost 3 years to decide whether they wish to return to the UK by the 29th of March 2022 with their existing close family members, and, if so, to make plans to do so. The immigration rules for this EU settlement scheme were changed accordingly. There are still 21 months remaining until this cut-off date. I turn now to the effect of Amendment 14 and the reasons the government does not agree with it. Amendment 14 seeks to provide UK nationals lawfully resident in the EEA or Switzerland by 31st December 2020 with preferential family reunion rights on an indefinite basis. Under the withdrawal agreements, EEA and Swiss citizens have lifetime rights to be joined here by existing family members as long as they themselves are resident in the UK by the end of the transition period. By contrast, the amendment does not specify a date by which the UK national must return to the UK, meaning they could return at any point in the future and continue to benefit from EU family reunion rules, which I suspect is the intention of the amendment. In addition, the amendment does not require the family relationship to exist by the date the UK left the EU, or even by the end of the transition period. This means, for example, a 25-year-old UK national could relocate to the EEA or Switzerland tomorrow, get married in 10 years' time, retire to the UK in 2060 and bring their spouse with them on EU free movement terms. Such preferential treatment is unfair and could not be justified so long after Britain has left the European Union. The family reunion rights of UK nationals returning to the UK from the EEA or Switzerland after the transition period are not covered by withdrawal agreements. Their family reunion rights should, after a reasonable period to plan accordingly, which our policy provides, be aligned with those of other UK nationals who have always resided in the UK or who seek to bring family members to the UK after a period of residence in a non-EEA country. To do so otherwise would be manifestly unfair to all other UK nationals wishing to live in the UK with family members from other countries and undermine the public confidence in our migration system and the objective of the family migration rules to ensure settlement is not done at the taxpayer's expense within the United Kingdom. Mr Chairman, I hope this sets out why we believe this is the appropriate balance to be struck in terms of moving towards a position of creating a single global migration system, but allowing a period of transition for UK nationals affected. And with that, I hope that the amendments will be withdrawn, but if they're not, the government will not be able to accept them.
Stuart MacDonald.
Excuse me, Mr Stringer, thank you. Grateful, excuse me. Grateful to the Minister for his response. I will have to go and look at the drafting of my amendment again, but while I may not have got it technically correct, I stand absolutely by the principle of what it's trying to achieve. The Minister and the Department have listened to UK nationals living in Europe and the EEA, and that is why they have put in place the transition period and the cut-off point of March 2022. But I've also listened to those very same people when they are saying to me that that is leaving an awful lot of them in with a huge dilemma, and I just don't understand the reason why the UK government insists that it has to happen like that. There is no need for a balance to be struck or any cut-off point to be put there. This is not, as the Minister expressed, a question of people bypassing domestic immigration rules. What the aim of this amendment is that to help people who moved abroad and formed family relationships in good faith at a time when there was no prospect of their right to return to this country with their family being impeded. They could have done that at that time on the basis of free movement rules. So as I say, Mr String, with your leave, I'll withdraw this amendment in the meantime so we can go away and work on it again, but I do stand by the principle and the intention behind it.
Is it your pleasure that the amendments be withdrawn?
Aye.
Amendment by leave withdrawn.